Welcome, everyone. My name is Greg Fox. I am on the faculty here at Wayne Law School, and I'm also the director of the program for international legal studies. For those of you who have come from far and wide to attend this talk, welcome, and thank you for coming. And I'm sure we're in for a very exciting hour of listening and discussion. It's a great pleasure for me to introduce my colleague, John Weinberg, known to most of you, but for those of you who do not know John, let me just give a brief introduction. John has been on the Wayne Law faculty since 1988. He is a prolific scholar on a variety of issues, immigration and citizenship issues being only one. He has written quite widely on issues of communication law, internet regulation, and other areas. John is a graduate of Harvard College and Columbia Law School. After law school, he clerked for then Judge Ruth Bader Ginsburg and then Justice Thurgood Marshall on the United States Supreme Court. And he has gone back into government in various capacities since then, mostly on issues related to communication. But today he's here to talk to us about a question that has multiple dimensions. Obviously, statutory questions, constitutional questions, and many policy questions, which is probably the form that you have seen the issue debated endlessly in the media and by politicians in Washington and in Michigan. So it's a great pleasure to welcome John Weinberg to talk about President Obama's executive actions on immigration. I should mention he came off of sabbatical just to give us the benefit of his wisdom.
So I'm excited to be giving this talk. I know a lot of people have been asking about this stuff. I'm here to talk about the administration's recent actions in immigration. There's been a lot of controversy there. One federal district court in D.C. has said that the actions are fully within the president's authority. Another court in Texas has issued an injunction calling a halt. Republicans in Congress for a while refused to pass a Department of Homeland Security funding bill unless it contained a rider stripping the administration of authority to go down this road. Eventually, Congress passed a clean bill without that language, but the whole thing is still tied up in the courts. So I want to explain today exactly what the administration is trying to do, what authority it has and doesn't have to do it, and what all the fuss is about. To get there, though, I'm going to have to give you a little background. And I'm going to do this in 4 areas. First of all, just pretty briefly, the history of migration to the U.S. Second, the concept of prosecutorial discretion as it applies to this stuff. Third, the concept of quote-unquote deferred action. And fourth, the concept of work authorization. And some of that may get just a smidge dense, but bear with me. Okay, let's start with one. Way back in the day, this country didn't have the same sort of restrictions on immigration as it has today. Until about 80 years ago, if you were white and European and you wanted to migrate to the U.S., you didn't need to worry about immigration law. You just got on a boat and you came. Period. End of story. That was it. That's how a whole lot of our grandparents and great-grandparents got here. Relatively free movement between Mexico and the U.S. lasted longer than 80 years ago. That history, I guess, starts with the 1848 Treaty of Guadalupe Hidalgo. Mexico cedes to this country most of the land that's now California, Arizona, New Mexico, Nevada, Utah, a bunch of parts of other states, which means that about 50,000 people get to immigrate to the U.S. without actually needing to get out of bed. At the outset, nobody's paying a whole lot of attention to the border. There's a bunch of movement to and fro. Indeed, the U.S. Border Patrol isn't even formed until the 1920s. By the early part of the 20th century, we see labor recruitment from north of the border, coupled with industrialization and land consolidation, forcing rural households off the land in Mexico. That's followed by a lot of refugee migration north during the Mexican Revolution in the teens. Combination of really aggressive demands for migrant labor in this country and economic and political turmoil in Mexico leads to an explosion of movement across the border following about 1910, reaches its peak in 1924, and again, though most of that migration is seen by the people doing the moving as temporary. It's enough to make some money, have the money, bring it back home. That migration pauses for a bunch of reasons in the 20s and during the Great Depression. But then we got World War II. Post-war boom. We need cheap labor here again. And the U.S. and Mexican governments in 1942 negotiate something called the Bracero Program. And that's for the importation of agricultural workers and temporary visas. Bracero program is driven by the need of Mexican workers to generate some cash to finance production on the land they kind of over there via agricultural reform programs. Also by huge demand from agricultural growers in Texas, California. That takes off by the late 1950s. The Bracero program is bringing into this country nearly 500,000 people a year. 1965 comes along 2%. First thing that happens in 1965, we end the Bracero program. And it turns out, working conditions of migrant farm workers are sort of deplorable. People in civil rights groups begin to notice. Bureaucracy imposes costs, there's corruption in the system as well. So Congress ends the program. This is all very well, except that growers need workers. They're not willing to go through with the pay hikes and working conditions improvements that they would need if they wanted to attract U.S. workers. And anyway, U.S. citizens don't want to do agricultural field work. After 2 decades, when this work has been done near exclusively by Mexicans, American workers see it as foreign. So we've got this huge built-in structural demand for immigrant labor. And at the same time, the folks in Mexico have gotten used to the money they could earn in the U.S., have developed a bunch of social capital, tied up in knowledge about what it's like to live and work in the U.S. and how to survive there. Plus, the economy over there tanks and there aren't a lot of jobs. Second thing that happens in 1965 is that Congress passes the Immigration Act in 1965 and puts in place a whole new immigration system that's substantially different than the one we had before. One aspect of the new system is the so-called preference system that, as things turn out, means that more or less nobody can come to the U.S. legally unless they've got a close relative here or a job waiting for them that the employer can't fill in America. Second thing is a rule that says, well, gee, within those constraints, we will admit people no matter where in the world they're from, but no more than 20,000 people from any given country per year. And that sounds sort of reasonable, that's fair. All countries get an equal shot. But think about that for a sec. Mexico gets put under the 20,000 person cap in 1976. This is the same country that not too long before had sent to the U.S. more than 400,000 people on temporary visas every year. That's not possible anymore. So what happens is the only thing that can happen, which is a sharp rise in illegal migration, mostly short-term, to fill the demands that the Bracero program had used to fill. There's more to it than that. An increasing share of the migration to the U.S. today is indeed not from Mexico, but from Central America. But that's, at least for our purposes right now, that's part of the historical path that led to our being where we are today. Namely, that there are more than 11 million people in the U.S. today, most of them from Mexico and Central America, who don't have legal immigration status. That's between 3 and 4% of the population. That's 5% of the labor force. Of the adults in that group, 60% of them have been here 10 years or more. 20%, it's more than 2 million people, have been here more than 20 years, and there is no provision in the immigration law for the vast majority of those folks to get legal status. Okay, so I want to start by making a basic point about those those 11 million people. We can't deport all of them, or even most of them. And when I say that, I am not making a normative statement, I'm making a descriptive one. This is not about what we want to do or what we want to do, no matter how much we might want it. We are not able to deport even a significant portion of that population absent a completely unrealistic level of spending. Because national deportation isn't free. Apprehension costs money, so does detention, so does transporting people back to their home countries, so do court hearings to ensure that ICE is in fact arrested the right people and their removals are in conformance with law. People are entitled to hearings before immigration judges, and we have only so many immigration judges. ICE estimates that it has the budgetary resources to deport less than 400,000 people a year. And 400,000 people sounds like a lot, but it's just a drop in the bucket when the population of people here without authorization is more than 11 million. Okay, so what then? Here we are. I mean, what then does the government committed to enforcement of the enforcement laws? Sorry. What then does the government committed to enforcement of the immigration laws do? There's a $6 phrase here, and the $6 phrase is prosecutorial discretion. That is, government figures out which of the 11 million plus enforcement targets there are in this country it's going to spend its enforcement dollars on. And the point I really want to emphasize here is that given everything I've just said, whether to use prosecutorial discretion is not a policy choice. How to use prosecutorial discretion is a policy choice. Government might decide it wants to prioritize felons. Might decide it wants to prioritize people with red hair. Or the people born on Tuesday. Or the people it finds out about first. Those are all policy choices government has to make. But whether to use prosecutorial discretion just flows inescapably from the reality that there are many, many, many more people in the U.S. without status than the agency has resources to take action against. The INS, Immigration and Naturalization Service, doesn't exist anymore under that name. It's been subsumed into the modern Department of Homeland Security. The INS first publicly released a document relating to prosecutorial discretion back in 1975, after a lawsuit arising out of its attempt to deport some foreign non-citizen musician named John Lennon. Who would thought? Anyway, in that document, they describe their use of prosecutorial discretion. They talk about it as revolving around quote-unquote humanitarian factors that cut against deportation of otherwise deportable people. Later on, in particular in the policy issues in 2000, the agency more closely ties prosecutorial discretion to sort of resource constraints that are driving the train now. It's reissued and updated the policy every so often since then. So we've got, say, DHS's current prosecutorial discretion policy was issued last November. Agency says, well, what it's choosing to do is to identify within the category of people living in the U.S. the following two groups as its top enforcement priorities. First group is basically people it deems pose a national security threat, plus people with criminal record, although you can get by if your crimes are very minor and there aren't very many of them. Second group includes people who have entered illegally since January 1, 2014, who are people who have evaded or ignored the removal order that was entered against them since January 1, 2014. But those, says the agency, are its priority groups. And as a general matter, its agency's decided it's going to devote its enforcement resources to those guys. It's not going to go after people it deems to be smaller fish, absent some good individualized reason. least that's the theory, that's the policy. It doesn't always work that way on the ground, but those are the rules the agency's adopted. And one more time, DHS could have defined its priority group some other way. That's a policy call, choosing those particular categories. But there's basically no avoiding the agency prioritizing its resources in some manner. Even if it had just decided, gee, you know, we're just going to deport the first 400,000 people we run into and then take the rest of the year off. No, that would have been a policy choice too. Okay, next piece of background, deferred action. Back in the 70s and 80s, when the agency first articulates its prosecutorial discretion policy, it explains that if it decided, as an exercise of discretion, not to deport a person, for now anyway, it would place them in what it referred to as a quote-unquote deferred action category. Meaning, we're not going to deport you for now, and we're deferring this. Maybe we'll deport you later, but we're not deporting you for now. Important to understand that deferred action is just a label. It doesn't change your legal status. When the agency puts someone in the deferred action category, when the agency puts someone today in the deferred action category, if that's you, you're still deportable. You don't get any pathway to legal status, much less a pathway to citizenship. Just that the agency has chosen that for now it's not going to deport you. Could change its mind and deport you later, but for now you're good. There are a couple of important consequences of deferred action label. I need to put those on the table here. First of all, Congress passes this law in 1986 that says it is illegal for a U.S. employer to hire an employee unless one of the following things is true. Either number one, that employee is a U.S. citizen, or number two, the employee is a lawful permanent resident, which is to say a green card holder, or number three, that employee is someone else the statute specifically says can be employed, or number four, that person is someone the agency has issued a rule saying could be employed, or more generally, that person is someone the agency has said is entitled to be employed in the U.S. So this statute basically gives the agency the job of promulgating rules saying who can get this work authorization, who is allowed legally to be hired in the U.S. And it does this. This is all going on back in the late 1980s. Agency grants work authorization to a bunch of classes of people who wouldn't otherwise have it, like people whose applications for benefits are hung up in the immigration bureaucracy. And in particular, back in 1987, agency promulgates rules says people in deferred action status are eligible for work authorization. And that's the basic concept here. The idea here is that the agency figures if it's already decided that it's not going to deport you for now, if it's already decided the better course, all things considered, is to let you stay in the country, then there's no sense in saying, well, we're not going to deport you for now, but we're going to make it illegal for you to work so you can stay here and starve to death. Agency figures instead, the people have deferred action status, they're going to be living here anyway, they might as well be working and contributing to the economy. And sort of the same theory. If you have work authorization, that's good enough in every state except Nebraska for you to get a driver's license. Nebraska, the situation is a little less clear and it's currently under litigation, but if you're in any of the other 49 states, that you're good. The state will get you a driver's license so you can get to the job that DHS has given you work authorization to take. Since 1986, government has granted deferred action and work authorization a lot to some fairly large groups of people. So that you got Attorney General Meeks under President Reagan. He exercises this discretion in 1987 to give the equivalent of deferred action and work authorization to about 150 to 200,000 Nicaraguans who are here illegally. Justice Department under the first President Bush uses the same authority to not deport about 80,000 Chinese nationals in the U.S. and to allow them to apply for work authorization. The law I mentioned that Congress passed in '86 had allowed a whole bunch bunch of folks illegally in the U.S. to legalize their status, but it didn't in fact do much for their spouses or children. So the Reagan and Bush administrations promulgate what they call a family fairness policy to give deferred action status and work authorization to about 1.5 million spouses and kids of those folks. Congress ultimately steps in to provide a more permanent status for them. So that brings us up to the past couple of years. That brings us up to the Obama administration. 2012, DHS puts in place what it calls the DACA, or Deferred Action for Childhood Arrivals program. DACA program grants deferred action and work authorization, where that's appropriate, to applicants basically who are no older than in their 20s now, who came to the U.S. as children, who've lived here continuously since 2007 or before, have a high school diploma or a GED or are currently in school, and have basically clean criminal records. And the concept, going parts, is that these people are especially good candidates for deferred action because they've grown up with this as their country. They're well positioned to contribute to the American economy, to American society, and their immigration status here is no fault of their own. That was 2012. Last fall, the administration, DHS, announces a new program called DACA, or Deferred Action for Parents of Americans and Lawful Permanent Residents. New programs directed at people who fall in the category of non-enforcement priority under DHS's prosecutorial discretion policy. Plus, they've lived in the U.S. for more than 5 years, and they have a kid who's a U.S. citizen or lawful permanent resident. Those people, too, under the DACA program, can apply for deferred action status, work authorization, although the administration reserves the right to say no based on this examination of the individual file. Now, something you should notice here is that the key impact of the DACA program doesn't relate to deportation. Because think about it, I mean, the people who are eligible for DACA are already unlikely to be deported, because we've already said they're non-enforcement priorities. You have to fall outside the priority enforcement categories to be eligible for the program in the first place. So the big practical impact of DACA is that it uses DHS's authority under the 1987 rules to allow U.S. residents with legal status children, clean criminal records, to step out of the shadows, get work authorization, get driver's licenses. These people are still deportable, but they won't in fact be deported unless and until the new president takes office with different enforcement priorities. Say in January of 2017. And the theory, for now, is that given that these folks aren't anyone the department wants to waste its enforcement resources on, there are humanitarian advantages in helping out families where the parents are supporting U.S. citizen or green card holding kids. Notice, by the way, for this work, that DACA recipients' parents aren't eligible for this program. Again, because DACA recipients don't have legal status. The only people who are eligible for this program are the parents of U.S. citizens or the parents of U.S. lawful permanent residents. The DACA program is the one that judge in Texas, Justin Jones. He actually issued his order on administrative law grounds. He said that under the Administrative Procedure Act, DHS should have requested public comment on the program before announcing it. We'll talk about it in the Q&A if you want. He made it pretty clear, though, that he thought that without regard to the procedural niceties, that he thought DACA was substantively illegal to boot. So is it? I mean, is this illegal? DHS says no, there's nothing new here. DHS says all it's doing is using prosecutorial discretion, which is something that doesn't really have a choice but to do. It's using its authority to grant deferred action and work authorization, which are well-established programs that have been in place for decades. DACA and DAPA, DHS says, are legally no different from what President Reagan did back in the day taking the exact same states, taking the exact same steps on behalf of 150 to 200,000 Nicaraguans who are illegally in the country. No different from the Family Fairness Program under Reagan and Bush. And the federal district court for the District of Columbia indeed agrees with that in a case called Arpaio v. Obama. And for what it's worth, so do I. I mean, I think DHS's arguments are exactly on the ball. There are, I think, though, some key questions that I think we need to address if we want to think this one through. First question is one that Senator and presidential candidate Ted Cruz has been asking a lot in congressional hearings. Does this mean that the president simply has the authority to suspend enforcement of the law if he feels like it? And the answer to that one's pretty clear to know. First of all, the Supreme Court told us in a case called Heckler against Cheney that the executive cannot adopt an enforcement policy, that is, here I'm going to quote, that is so extreme as to amount to an abdication of its enforcement responsibilities. So on that level, it's pretty clear that the president can't just wake up one day and say, hey, I've decided to stop enforcing the Clean Air Act. No more, it's done, not doing that. That's not okay, that's what the Supreme Court would call abdication. Judge Hannon, who's the judge in the Texas case, said that DACA was a similar abdication of the executive's responsibilities under the immigration law. But that actually seems like a pretty odd thing to say, since one other thing going on here is that in the larger picture, the administration is enforcing the hell out of the immigration law. It is deporting people very aggressively and in high numbers. There are a huge number of deportations going on, just mostly not the sort of people who would be benefited by DACA. So yeah, the administration's exercising prosecutorial discretion, but that's its job. But there's a second limitation on the president's freedom to enforce the law as he sees fit, which is that he's got the leeway to make prosecutorial discretion choices. And that's what he was elected to do. But he can't make choices that are inconsistent with instructions in the statutory text, or that are, what that law calls arbitrary and capricious. That are not something any reasonable person would choose, in light of what the statute is there to achieve. And so, yeah, it would be a problem set if DHS adopted the prosecutorial discretion policy that says, gee, we're going to deport only law-abiding people and keep the people who have committed crimes here. But that's not what the administration's policy looks like. And I think, therefore, where that leaves us, or where that takes us, is the following argument that opponents of DACA might make. Sometimes do make, sometimes don't make, but not quite in this form. Which is, gee, they would say, here's the problem with this policy. That in practice, here's the basis for our claim to illegality of this policy. It says, in practice, they might say, enforcement of the immigration law requires tolerating the presence here of millions of people in the U.S. without lawful status. Okay, we got that. Common ground, so far, so good. But they continue. The policies embodied in the immigration laws require making those people's lives as inconvenient and miserable as possible. Working illegally and under the table, driving without licenses, constantly in fear. What DACA does, or what DACA would do if it ever got to go into effect, is to allow people here without authorization to live more nearly normal lives. And okay, they say that's all right when we're giving people deferred action for humanitarian reasons, but it's an impermissible policy choice, inconsistent with the core of what the immigration statute has to be read to require, and when it's applied to millions of people here illegally who are simply low targets for enforcement. In a lot of ways, I think that's the best argument against these policies. You know, and I think it's not 100% crazy, but in the end, I think it doesn't work. Because fact is, I mean, there are a lot of policy choices that DHS could make consistently with the immigration laws on the books. You know, that address the reality that 5% of the U.S. workforce doesn't have legal status. Senator Cruz's way, just immiseration. You know, that's one possible policy choice. The President Obama's way, integration. That's another possible choice. I mean, they're both within the range of enforcement possibilities. This is why we have presidential elections. House and Senate could vote if they accumulate sufficient margins to overcome a veto to forbid programs like DACA. That's their role. That's why we have congressional elections. But absent such a statute, Judge Hannon in Texas notwithstanding, it's hard for me to see why this isn't a choice for the administration in office to make. And then I think is the core of it. We've got a little time, so let me take some questions. I'm guessing there are questions. We can take it from there.
I think we have a microphone somewhere. Yes, if you could hand that to whoever's asking the question. Thank you.
John, what about the ad law issue, the notice and comment period?
The ad law issue is actually a much closer issue, I think, than the constitutional issue. Here's the deal in a nutshell. That the Administrative Procedure Act says that before the government can promulgate a rule or a legislative rule, which terms are terms of art, it needs to give the public an opportunity to comment first. The administration says, here's the rule we're thinking of promulgating, and the public can say, well, here's why we think this is a bad idea, or a good idea, or maybe almost a good idea, but you should tweak it in the following way. And the government is supposed to take those comments into account before making its final decision. And it's uncontroverted that the government didn't do that here. So the question is, well, was this a rule, or a legislative rule, within the meaning of the APA? And the government has suggested two arguments as to why it isn't. One of them, they say, is that this isn't about any enforcement action that we're proposing to take. This isn't about how we plan to use the law to slam people. This law is only about what enforcement action we propose to not take. This law is sending out our plans for things we intend to not do in the future. And to the extent that all we're talking about are things we're not doing, and say that's not subject to the APA at all. Second thing the government says is that as a practical matter, there are two categories of things an agency might say that might be classed as triggering the need to think about this APA Section 553 requirements. One is where the agency changes the law. Back in 1987, when people with deferred action were not entitled to apply for work authorization unless there was a rule saying so, and the agency promulgated that rule, then that changed the law, and there needed to be notice and comment, and there was notice and comments. But there's another class of cases where the agency isn't changing the law. The law is what it is. The agency is just saying what its intentions are, what its plans are, how it intends to work within the law. And the U.S. has made an argument here. Well, this is that. We're not changing the law. Law is what it is. Was same thing before, same thing after. All we're doing is that we are giving people a heads up as to how we plan to work within it. here are our intentions as to who we think we might give deferred action to or who not. Here is the guideline. If you're interested in applying for deferred actions, these are the applications we figure we'll likely grant. These are the applications we figure we likely won't. And the U.S. says, once again, that's not the sort of thing that the notice of comments requirement applies to. See, this one, well, in terms of predicting what other courts will do, we have the problem that Judge Hannon is in Texas. Talk more about that. That means appeals from Judge Hannon's decision are to the Fifth Circuit. The Fifth Circuit has something like 15 Republicans and 3 Democrats, and has issued all sorts of opinions in the past few years that they would not have thought that I would not have believed until they happened. So I'm never casually going to predict that the Fifth Circuit will reverse any decision in joining an Obama administration program. The constitutional issue, I think the law is really strongly, but properly understood, the law is just overwhelmingly in favor of the administration. And the Fifth Circuit will be addressing the case on that background, no matter how they roll. When it comes to the notice of comment issue, I think the issue, especially given some of the actual Fifth Circuit precedent out there, is a lot more cloudy. So I wouldn't be surprised if Judge Hannon's upheld on the APA issue. One more issue in this case I haven't talked about at all, but which is also worth attention when we're doing prediction, which is that this case was brought by, as a lawsuit by a bunch of states. Texas, better part of 30 other states, the Attorney General of Michigan, not the state of Michigan, but the Attorney General of Michigan suing in his official capacity. And one question that might be raised is, well, what's Texas's standing to bring this lawsuit? What's the standing of any of these states to bring a lawsuit? If the U.S. Wants to grant deferred action, work authorization to a bunch of folks, how is that a constitutionally cognizable injury to the state of Texas? And Judge Hannon issues a long and, in a lot of ways, really quite problematic ruling saying that yes, Texas has standing, and the core of the ruling is that, gee, if a bunch of people in Texas get deferred action, then Texas will be issuing them driver's licenses. And it costs money to issue driver's licenses. So therefore it will cost Texas money if people get deferred action, ergo Texas is standing. Which, if you think about it, actually has all sorts of problems. Number one, just as a technical matter. This may be too inside baseball, but I'll put it out there. It clearly costs Texas money on a fixed cost basis to issue driver's licenses. I mean, they've got a DMV. If you divide, the number of licenses issued by the cost of running a DMV, you get a number. The number is larger than zero. But there's no showing of what the marginal cost is to Texas to issue driver's licenses. If all of the new people can be accommodated with the same staff, then no, it's not costing Texas anything. But even beyond that, well, two more things. Number one, this is the same quote-unquote injury that Texas suffers whenever anybody moves to Texas. And it's sort of weird to think about how desperately Texas is hurt by people, moving to and working in the state of Texas and paying taxes there and doing all those good things Texas wants when it runs ads in other states saying, hey, move to Texas. Third thing is that, if we take Judge Hannon's theory seriously, this isn't merely triggered by millions of people getting deferred action. Texas similarly would have standing to sue the U.S. government if it gave even one person deferred action. If I say, gee, I'm scheduled to fly back to Poland, but, my mother is dying in Houston, so can I please stay here in deferred action status to take care of her? And the U.S. government says, sure. Under Judge Hammond's theory, Texas would have standing to sue the U.S. government to stop it from giving me deferred action because they say, oh my God, we might get a driver's license. And that's just weird. So, again, if this were a federal court of appeals other than the Fifth Circuit, I would say there's a very strong chance of this ruling being reversed on standing grounds. Given that it's the Fifth Circuit, anything can happen.
Thank you, Mr. Weinberg. My question is, what effects, if any effect, do you think that these recent developments would have on the comprehensive immigration reform that's been proposed?
But for a long time, people have been saying about the facts that, let me take a step back. I started out this talk by saying that we have 11 million people without status here in the U.S. The one thing basically everybody involved in the immigration debates agrees on, whether they're on the right, whatever that means, the left, whatever that means, whatever their position is, they all agree that having 11 million people without status in the U.S. is a bad thing. That you may think it's a bad thing because it means that we're tolerating all this lawlessness and these people ought to be deported. You may think it's a bad thing because that means we have 11 million people who can be badly exploited by virtue of illegal status and their status ought to be legalized. But no one thinks it's desirable to have an underclass of people, of 11 million people who have no legal rights because the law says they're not even supposed to be here. So for a long time, people have been talking, can't we find some sort of global legislative fix that'll solve these problems? And people over the years have proposed and tried to negotiate legal fixes. There was one that seemed past the Senate a few years back, seemed as if it might go somewhere, never did. Indeed, passed the Senate by a really large, whopping bipartisan margin. That said, I think it's been clear for the past couple of years that at least for the foreseeable future, comprehensive immigration reform is dead. Not gonna happen. Priming for the fjords, propping up the daisies. It is an prospective statutes. There is simply not gonna be comprehensive immigration reform. So sometimes people have said, well, gee, Mr. President, if you move forward on your own with a program like this, you're gonna make some people angry, and that's gonna jeopardize comprehensive immigration reform. But you know what? There's not gonna be comprehensive immigration reform. And I think that's one of the things that's emboldened this administration to say, okay, well, what can we do with our existing authority? And the answer is not much, since after all, anything this administration does can be undone with a stroke of the pen in the next administration. But nonetheless, it's emboldened this administration to say, well, what can we do with our existing legal authority, given that comprehensive immigration reform isn't going to happen?
Thank you. Yeah, Jose Coelho, Latino Studies Center and Department of History. I was wondering what you think is the fundamental cause of resistance to comprehensive humanitarian immigration reform. My own view is that it's a kind of a nativist ideology that sees foreigners as destroying American culture, and then the event reasons, whether it's the economic reasons about the cost of licenses or hospital care or whatever, anything that a human being would need, they want to deny. And is there a possibility of breaking that? I mean, do you agree that it's nativist, or do you see some real other reasons for this?
Well, I think there are two ways to parse out the opposition, although they both sorts of opposition in the end have the same roots, which is that one way we can ask this question is, what are the sources of opposition, among those segments of the American people who are hostile to increased immigration or hostile to regularization of status, all that. The other way we can parse out the question is, what are the sources of opposition in the U.S. Congress, and in particular in the U.S. House of Representatives? The U.S. Congress is actually a much harder nut to crack than the American people, because right now, the way that the U.S. House of Representatives is structured, we've got a majority of the U.S. House that's serving from state Republican seats, where the only political challenge they have any reason to worry about is a challenge from the Tea Party right. And those guys are not going to support immigration reform because there's nothing in it for them. It can only cause them to run the risk of not being reelected. It can't help them be reelected. And that's one of the reasons I think comprehensive immigration reform isn't happening in the foreseeable future. That if we look more broadly and we say, what's the source of resistance in the American public at large? And I think that you're absolutely right, that what you referred to as nativism is just a huge component of that. And there are those who would say, in slightly bolder terms, that what one might refer to as racism is a huge component of that. It's certainly not the only component, and one of the things that's really striking about immigration policy is the extent to which these issues find themselves with strange bedfellows, where you might have liberal Democrats and conservative Republicans banding together on immigration policy, and there's similar crossing of party and ideological lines. But it's sort of hard to imagine what immigration policy in this country would look like if it didn't have that nativist component.
Chuck, maybe I can ask a question to kind of move back to the more technical legal questions. First, why didn't Homeland Security allow for public comment? I mean, it seems like a relatively costly thing to do. It would avoid the question in court. Secondly, on standing, I think your view is pretty clear that the states don't have standing. Say nothing of the Michigan Attorney General's personal capacity. But if the states don't have, states which presumably would, might in theory absorb some administrative costs of these new folks in their midst, they would have standing. Would there be any potential plaintiffs? Because, as we've gone through this debate with King versus Burwell, you can raise standing questions, but if your goal is to get the merits, and it seems likely that other more worthy plaintiffs will just reappear, what's the point of arguing?
Right. Two main points there. The first one is that, in fact, seeking public comment, as it turns out, and there may be other reasons we can return to, but at least the point to make right beside is that seeking public comment, as it turns out, is not cost-free. Seeking public comment is incredibly expensive. And the reason for that is that the government is required not only to collect the comments, the government is required now to collect them, and to read them, and to respond to them in its ultimate documents. So if you're a government agency, like the FCC, that not infrequently collects literally millions of public comments in response to some of its proposals, well, there are double-way consulting companies whose only business is hiring out to government agencies to collect and collate and digest and allow the agency to respond to those millions of comments. And so that's certainly, in the best of circumstances, not going to take less than a year to do. Which, in the case of this administration, would butt us up right against the presidential election. So, a ruling that the administration has to collect on this comment is actually is not a mere technical thing. It's a very big deal. And the administration in this case felt that it was a pretty strong grounds in saying that no, we think this is merely what in APA terms is called a general statement of policy, rather than what in APA terms is called the legislative rule. Second thing, in terms of who would have standing, this actually comes up a lot in the context of, in administrative law, in the context of what is sometimes called non-enforcement decisions. Because it's easy to know who has standing to challenge the agency when the agency is taking enforcement action. The target of the enforcement action has standing to make the challenge. Who, though, has standing to sue when the agency is declining to take enforcement action? Very often the answer is nobody. Very often the answer is that you don't like the facts that the government is declining to take enforcement action. Your recourse is at the next election. You vote out the guys who aren't enforcing the statute the way you want them to, and vote in some other guys who will. But it's not clear that this doesn't fall within that category. There are a number of Supreme Court standing cases. One of them that comes to mind is a case in the Supreme Court called Air Couriers, where the Postal Service changes its rules to make more carriage options possible in a way that disadvantages the postal unions. And the postal unions sue. And the court says, sorry, this doesn't happen to be one that anybody has standing to challenge. One more thing, by the way. I guess I shouldn't let the hour go by without mentioning. We've got Judge Hannon issuing this ruling, and Judge Hannon is stretching very far to find standing here. He's also very clear in his belief that the administration's actions are just lawless and irresponsible and exposing the U.S. to a tremendous threat from the Southern menace. You might ask the question, why was it Judge Hannon, of all people, who's making this ruling? And the answer is that the folks in the Texas Attorney General's office are no fools. That they know what Judge Hannon thinks because he's made these views clear on paper before. And Judge Hannon sits in Brownsville, and they file in Brownsville, and there's some confusion on this. He's either the only federal judge sitting in Brownsville or one of two. So, and a member of the audience is saying, no, it's two. But even so, you file in Brownsville, you've got a 50% chance of getting Andrew Hannon. And now you're going to be filing lawsuits out there. Some of you come today. Keep that in mind.
You touched on it earlier when you brought up Ted Cruz. Can you elaborate more on the argument as to why a future Republican president could not use the same action to provide tax relief or any conservative agenda like EPA regulations, anything like that? Why is that different? What does not look like that?
Well, in fact, this isn't just an immigration law that government agencies all the time make prosecutorial discretion choices as to what sort of cases they're going to pursue. and what sort of cases they're going to ignore. In that sense, it's not a matter of what would stop future presidents from doing this. Future presidents are going to do this in a variety of areas. Past presidents have done this in a variety of areas. There was one well-known case about how turns out the FDA, won't take action against you for selling adulterated grain, if the percentage of the insect parts in your grain is below a certain thresholds. So, which means basically, another way of putting it is FDA is saying, insect parts in your, if you leave insect parts in people's grain, well, you got a free pass, we won't touch you. Until it gets too bad. And at that point, we'll take enforcement action. There are limits on agencies' ability to do that. The main limits are, what are the limits? The limits are, number one, application, which we talked about. Number two, the rule can't be arbitrary or capricious in light of what the statute's there to do. Number three, it's probably relevant here. Is the agency, in fact, using all of its resource dollars to enforce the statutes? Or is the agency saying, hi, we've got a $80 million budget, and we're going to do $6 million worth of enforcement, and the other 72 are just going to throw pool parties with? If the agency is making an enforcement choice that doesn't make sense, that's inconsistent with the statutes, and that just doesn't pass the smell test in connection with the agency simply leaving its enforcement dollars on the table, that's going to be a problem. In this case, what the agency is doing is it's using all of its enforcement money. It's making some choices as to who it wants to enforce against. It's making choices that I've at least argued are within the range of possibilities that are in fact consistent with the statutes. And agencies have done that before, and agencies will do that again.
Well, going once, going twice. Okay, with no more questions, please thank John Weinberg.